Hi, this is Mark Sokolow. This is one of my videos, and we're dealing with just a brief snapshot of litigation. Um, the purpose of this video is for my business law students. I've been an attorney for over 30 years, board certified in civil trial litigation by the Texas Board of Legal Specialization. I managed litigation for numerous cities for over 20 years as their city attorney. What you're going to be seeing in this video is really just a snapshot of the litigation process. We're going to review some of the basic pleadings. If you do get sued, you need to promptly contact your own attorney, and you also need to contact your insurance company. I hope you enjoy the video. Hi, this is Mark Sokolow again, and we're going to be looking at a lesson plan for my business law students. And we're going to basically be looking at civil litigation. I've been involved in litigation and managing litigation for over 20 years, and I'm board certified in civil trial litigation by the Texas Board of Legal Specialization. Anyway, you can just have a dispute. It could be any type, a car accident, an explosion, not being paid. First thing you have to do is review the facts and determine whether or not you have a legal cause of action. In other words, a right to sue someone. Someone can do something to you, but you may not have the right to actually bring a lawsuit against them. So what causes of action are recognized? For example, the Texas Deceptive Trade Practice Act, where if you lie about your warranty or the quality of your goods, you can be sued. Slander, where you say something bad about someone, you can be sued. Malpractice. If you commit medical malpractice, you can be sued. If you're negligent, you can be sued. Statute of limitations simply means that you can't hold on to the lawsuit forever. In other words, at some point you got sued. And if you wait too long, you lose your rights. So you'd say for slander or libel, there's a 1-year statute of limitation. For personal injury, you'd say an auto accident, it's a 2-year statute of limitation. For debts or contracts, it's pretty much a 4-year statute of limitation. Sometimes, you have to look under the law, see what type of damages can you get. Is it actual damages? Is it punitive damages? Is there statutory limits to them? Are there any applicable procedures before you file suit or within a certain amount of time? Like engineers, if you sue an engineer, you need to get an expert report from another engineer that the first one committed malpractice or was negligent. Also, you may or may not be able to recover attorney's fees. Sometimes you're allowed to, sometimes you're not. Filing fees, court costs, you may or may not be able to recover them. For the most part, if you prevail, you recover litigation costs. Which court? In Texas, you have Justice of the Peace, county, district. We're looking at state district court. And for the most part, on those type of trial courts, it's the amount of money involved that decides which court you file in. When you go to federal court, it's usually a federal cause of action. You'd say a Dodd-Frank action, securities, or bankruptcy. Well, bankruptcy, they have their own bankruptcy courts, but you'd say it's a securities case. Or diversity, in other words, citizens of one state is suing citizens of another state. You got to look in your agreements before you sue to see whether or not you have an arbitration or mediation clause that where you have to, if it's an arbitration clause, you really need to go to arbitration instead of litigation. If it's mediation, it means you need to at least try that settlement procedures before you sue. What venue? This is basically, you're going to a district court, but which district court in Texas? Is it the one in Harris County? Is it the one in Jefferson County? Venue is kind of just the location of the court. What controlling law? You have a situation where you have a Texas company selling goods to a Louisiana customer. Which law is applicable? These are the questions that need to be answered. Of course, you need to hire an experienced attorney with a fee agreement in writing, whether it's hourly, contingent. And then you get into the basic process, and later we're going to actually go over just some of the basic pleadings so you have an idea. You file a petition. This is simply what it's about. It's a complaint. It says on the top of it, you against the defendant, and it just says what type of lawsuit it is. What's the facts? You file it, you pay filing fees. You'd say you file with the district clerk. The clerk assigns the number and assigns a judge. A citation is ordered, and I'll show you a sample one in a few minutes. The petition is actually served by a constable, even though sometimes you get private service. The defendant usually has a certain amount of days, well, they do have a certain amount of days to answer. And I'll show you an answer in a few minutes. Defendants, if they have a cause of action against you, can file a counterclaim. Then you go into the discovery period. One of the things in Texas is you don't have trial by ambush. In other words, before the trial, each side is supposed to get the relevant evidence from the other side. You can do it by questions, which are interrogatories, requests for admissions, which simply is documents as admit or deny, depositions, where you can actually take testimony of someone before the trial, requests for production of records, and that brings one thing out. If you are being sued, you really need, or if you find out that you have a claim against you, you need to preserve your records. And that's especially important for corporations. When you file a lawsuit, you're supposed to designate a discovery control plan. In other words, it's just a time limits for discovery. You can have various motions that you may want to bring before the judge before the trial starts. Motion to compel discovery. Someone isn't producing things they're supposed to produce. Motion for protective order, where so you feel like someone's abusing the discovery process. Motion for sanctions if you think someone destroyed evidence or destroyed records. Motion for default judgment, that's where someone didn't answer the lawsuit. Motion for summary judgment, that's where, based on all the facts as even looked at as alleged by the defendant, you win. A lot of times in Texas courts, they ask you to go to mediation before the trial actually begins. Mediation is just a fancy settlement conference with a facilitator. It's confidential. If it works, it works. If it doesn't work, it doesn't work. You show up at docket call. You have motions in limine, which basically, for the most part, you're telling the jury these are motions where you're trying to get a judge's order to prevent the other side from usually saying something. In other words, you don't want to tell the jury that the other party has insurance. You don't want any of the witnesses. You don't want the attorneys to say that the other side has insurance, or that you have insurance. Voir dire, that's just the part of the case where you select the jury, or really, it's a procedure. You'd say you bring a panel of 40, each side gets to strike 6, and the remaining 12 is on your panel. One thing you need to remember, all our trials are public. The judge is passive. He rules on the process, whether it's legal or not. He looks at the evidence. If there's objections, he rules on whether it's admissible or not. Each side, when you start off, you have an opening statement from the plaintiff. He usually starts off. Well, he does start off. The plaintiff has the burden of proof of his cause of action. He presents witnesses. The other side can cross-examine. Objections are usually in the form of hearsay. In other words, you're not supposed to say something that someone else said to you. Relevance, leading. In other words, is the testimony relevant? Leading questions. You're not supposed to have leading questions where you're actually telling the witness what it says. What they're supposed to say is like, what's an example of leading question? On the 5th day of March, isn't it true that you saw Miss James go down the street at 80 miles per hour? You're telling them what the answer is. That's leading. After the plaintiff rests, the defendant presents their case. Witnesses are, after he calls a witness to the stand, they're sworn to tell the truth, the whole truth, and nothing but the truth. They ask the name, they ask questions, the other side can cross-examine. When both sides have presented their evidence, you have closing statements. You have preparation of the special issues, which simply are the questions that go to the jury. The jury comes back with a verdict. You have entry of judgment. And then someone can appeal. I know this is pretty quick, but this whole video is designed for just a quick snapshot of the litigation process for my business students. The court system for civil litigation, you have 2 tracks, federal courts or state courts. You have to decide which way you want to go. Of course, it depends what the cause of action is, or whether or not you have diversity. In Texas, as I said, state court jurisdiction is for most part based on the amount of controversy. In other words, how much money is involved. There's various causes of action. You can be involved in court if you appeal your appraisal. If someone breaches a contract, that's a cause of action. You have a contract, you claim the other side breached it. Condemnation. Those are when the government wants to condemn your property. You usually have a commissioner's hearing. In that type of case, you go to county court. Conversion. These are just various theories where you can sue someone. Conversion when someone took your property. Discrimination. You can sue someone for discrimination under the Labor Code in Texas court or under the EOC in federal court. Dram shop liability. That's where you're selling alcoholic beverages to an obviously intoxicated person who injures someone. In other words, you have a bar and you're selling someone who's total drunk and they go out there and get an auto accident. Under dram shop law, you can sue the people that got injured can sue the bar. Texas Deceptive Trade Practice Act. We're going to go over this in more detail in a later video. But it's basically where you're suing a business for misleading or deceptive acts. Fraud, someone makes a false representation to you and it causes you damage. And personal injury, this is a typical auto accident case. Someone has duty of care, driving safely, they breach the duty. In other words, they're speeding, they're driving poorly, and they cause an accident and you damages. When you get down, this is just a list from the U.S. District Court of all the different causes of action. I found this in the District Court in Arizona, but it's a pretty good list. There are just numerous causes of action out there. And when you file the lawsuit with the court, they just keep records of all the various causes of action, whether it's a civil, whether it's a Freedom of Information Act, whether it's a labor lawsuit, whether it's bankruptcy litigation, securities fraud. Well, bankruptcy, they have their own bankruptcy court. We have trademark infringement, truth in lending cases. It's just a laundry list. A RICO lawsuit. And these are federal causes of action. Employment discrimination. When you're in business, you need to make sure you don't pollute. If you do, you could violate the Clean Water Act or the Clean Air Act. Okay, our next thing we're going to look at is just a few rules of the Texas Rules of Civil Procedure. When you start a lawsuit, one of the first things you need to designate is the discovery control plan. All this is depending on the amount of money and the type of suits, is how's the discovery? In other words, the discovery of the evidence. You want to find out what evidence the defendant has. The defendant wants to find out what evidence you have. And on a level 1, this is for lawsuits involving $50,000 or less. We're looking at Texas rules. All discovery must be conducted during the discovery period, which begins when the suit is filed and continues until 180 days. It's about 6 months. The amount of depositions, that's where you can have someone testify in private chambers. For a court reporter, you can have no more than 6 hours in total to examine all witnesses. Interrogatories, you may not serve more than 15 written interrogatories. Requests for production, no more than 15. Requests for admissions, no more than 15. So this is really very limited. Discovery Control Plan 2, it's a little bit more broader. All discovery must be conducted during the discovery period, which begins when suit is filed and continues until 30 days before the date set for trial. That involves family code. Or in other cases, the earlier 30 days before the date set for trial, or 9 months after the earlier date of the first oral deposition, or the due date of the first response to written discovery. Basically, it just gives you timelines. In interrogatories, it limits you to 25 written interrogatories. Oral depositions, you can have no more than 50 hours in oral depositions. That's quite a lot, actually. And then you have what's called you can go to the court to ask for the discovery plan to be modified. And discovery control plan number 3 this is more like you're just tailoring your own plan. Now, interrogatories are simply questions. Request for production is obviously you're asking the other side to produce documents. Now we're going to actually look at actual examples of pleadings. Hi, this is Mark Sokolow again. Okay, what we have here is it's just an example. It's a real example where Target National Bank is suing Victoria Santibanez. This is called the caption right here. And when you file a lawsuit, this right here is left blank, and this is left blank. And this is the plaintiff, person who's suing, and they're suing Victoria Santibanez. And of course, you put what it's all about, the label of the documents, the plaintiff's or original petitions, that's the title. It's in the district court, which can hear it's the highest trial court in Texas. It's in Harris County, so the venue of it's in Harris County. That's the location of the court. District court's the type of court. In other words, it's not JP, it's not county, it's district court. The title of the document is plaintiff's original petition. Usually start off to the Honorable Judge of said court. Target complains of Victoria Santibanez, and for the cause of action, in other words, the theory of suit would show the court won. Their discoveries intend to be conducted under level 2. So what they're doing here is simply saying it's rule level 2. They're describing who they are. Plaintiff's the National Bank. They're saying that defendant is a resident of Harris County, and they're showing where service can be had. Venue is proper in this court because they're saying the defendant resides in this county. In other words, you can sue someone in this county, and the amount of controversy is within the jurisdictional limits of this court. And basically they're saying it's a breach of written contract. That's the type of lawsuit. They entered into a card member agreement, and basically the bank made cash advances to the defendant, and the defendant has basically failed to pay Target back. And they're saying the amount due is $3,723.37. And so the plaintiff is asking that they be cited to appear and answer, and that they have judgment against the defendant for $3,723 plus cost of court plus post-judgment interest, and for any other relief to which you're entitled. And of course, the lawyer filed it, signs off, and shows his bar number. So that's a petition. You got to remember, all these pleadings are public. Now this is a citation. It's a different case, but it's a citation. When you get served with a petition, it comes with a citation. In this case, it's a citation where actually it's a citation, and when you receive it, it says you have been sued, you may employ an attorney, but it says if you or your attorney do not file a written answer with the clerk who issued this citation by 10 a.m. on the next Monday, next following the expiration of 20 days, a default judgment may be entered against you. In other words, you can lose. And so when you get served with a petition, really the first thing you need to do is contact your insurance company if you have liability insurance, because and then they'll retain an attorney to file an answer. But if you don't have insurance, seek an attorney or do what you need to do, but you need to file an answer within the time period as stated in the citation. Now this is what the constable wrote. So in other words, when the constable goes out and serves you, in this case he wrote down the name of the person that received the service. Now this is an example of an answer. It's actually a different case. For whatever reason, they marked off the number and names, but it's all public record. And basically, the defendant files an answer. In this case, the City of Port Arthur, and they're simply filing an answer. It's a general denial. Under Rule 92 of the Texas Rules of Civil Procedure, at that time, depending on the case, you can just say, "I generally deny everything," and then the case starts. You do a certificate of service. In other words, you file this pleading in the courthouse, and you need to give a copy or mail a copy to the other lawyer. In this case, he served the counsel for plaintiff. This is called a certificate of service. Now, this is just an example of discovery. This is a case where the City of Port Arthur was being sued, and they're sending discovery or request for production to plaintiff. And they're basically asking they're sending discovery to the plaintiff. In this case, just take a look at the type of documents. Of course, the lawyer signs it and sends it to the other side. This is the type of documents they're asking the plaintiff to produce. Any type of statements made by the defendant that they have, copies of correspondence, reports of any expert that may pertain to the case, any pictures, diagrams of the accident scene. I believe this involved an auto accident. So you're trying to get all the records, any evidence, all physical evidence. You want to try to get their employment and wage and income record. If someone's suing you in an auto accident and claiming lost wages, you have a right to ask for their income statements and their medical records if they're claiming injuries. This is an example of interrogatories. It was served on the plaintiff. It's a different case, but interrogatories, just questions. Please identify the plaintiff, including but not limited to your date of birth, name, social security number, driver's license. They're asking you for records about who you are. In other words, the plaintiff sued, in this case, City of Port Arthur. They're asking who you are. They're going to check you out. You're claiming injury, so give us all the information on anybody who's ever diagnosed you. Designate right here any injuries you claim. Describe all physical, psychological, mental, emotional illnesses that you've had for the last 10 years. Describe all your medical expenses. So you're suing someone in an auto accident, or in this case, the city's being sued based on an auto accident, and the city's saying, okay, you sued me, you need to produce your income records, you need to produce your records on your medical, so I know what's going on. If you have any statements or videos of the scene, you need to produce them. And you describe how the accident occurred. If you have any, they want to know whether or not you've ever sued anyone before. Now, this is what's called a request for disclosure, and basically, it's more of a, let me go back to that, request for disclosure. All they're doing here is you produce the stuff that is denoted under Rule 194.2 through 194.2K. All that is a list of topics that you're supposed to produce, and one of the items is, you'd say, expert reports. This is an example. It's of Enron creditors versus Christian Raham of what a final judgment looks like. In other words, in this case, the judge granted the motion of the plaintiff. In other words, the plaintiff filed a motion under the law that basically indicated that they should win the case. The judge reviewed the motion, said that you win, and in this case says that they get a judgment over $354,000 against the defendant. This is what's called an abstracted judgment. In other words, if you get a judgment entered against you, you can actually have that judgment entered into the real estate records. And that's exactly what an abstract does. So that it's sort of like a lien that's placed on your property. Well, it is. It's a judgment, and so everybody knows that you had this judgment against you. This is a writ of execution. In this case, there was a judgment against a company, and what this does is authorize the constables to go out there and seize property, seize non-exempt property to collect on the judgment. What this is during the case, the judgment got paid, so you file what's called a satisfaction of judgment and discharging the defendant from the judgment. So this has pretty much been just a real snapshot of the litigation process. Some things you need to remember is if you get sued, of course, always remember to read it, forward it promptly to your insurance company if you have liability insurance. If you don't, promptly go see an attorney of your own choice.